So, my name is Bernie Musry. I'm a solicitor specializing in litigation, and joining me today is Mr. Chapman Mansfield, who's a solicitor practicing in personal injury.
Good to have you. Good to be here.
All right. Welcome to the Caselaw Club. Okay. So today we have the case of Chapman and Gibbo's Transport Pty Ltd and others. It's a 2023 case, number 2, New South Wales Supreme Court, number 186. So in August of 2016, we have our injured party who was driving a truck carrying flour, so it's his job, for Gibbo's Pty Ltd, from Manildra, New South Wales.
Yep.
Am I getting that right?
I think so, yeah.
To Sydney. And he had an accident, quite a severe accident. He was left with quite severe injuries. And included in that was
Traumatic brain injury. Yeah.
So after the accident, him and his wife, because he was quite severely injured and he was going through medical procedures when he was consulting with lawyers, so it was substantially, his wife was involved in a lot of this. They launched an action against the employer for work-related injury damages, and they then later on in the track then joined the owner of the vehicle, so the company provided the truck. The matter continued to be run on the basis that it was a work-related claim until roughly 2022 is my reading of it from the case. So this is just the preliminary history of the case so far. Then it went before Her Honour Adams J. On the 1st of June 2022. The court considered a notice of motion by the second defendant seeking to amend the defence. So the defence was sought to be amended on the basis that the claim was prohibited pursuant to Section 108 of the
MACA.
Motor Accidents Compensation Act, 1999. Here, Her Honour allowed the defence to be amended, and they also sought summary dismissal to throw the case out, but Her Honour said no, that's a question, a valid question to be answered for trial, so we'll wait till that trial. Now, at this point, we should note that the injured party and his wife had been receiving legal advice and been consulting with lawyers since like 2016. 2016 is when the incident occurred. But during that time, the possibility of a motor vehicle accident claim had come up, but it was fairly early on in the process and they hadn't received a proper advice on whether it was or was not. And they had come to the conclusion that, on a preliminary basis at least, that it was likely not going to be available.
Right.
So it hadn't been considered properly until this amended defence was brought up, where they said, well, okay, this is a motor vehicle accident claim. So firstly, you're out of time on that claim, and that excludes it from other liability. So they said, okay. So they filed, and they sought to amend their claim to add additional basis and alternative to counterclaim under MACA, which is where this particular decision comes in. So we have the time limitations clause, which is Section 109. The time limitations on commencement of court actions. Claimant is not entitled to commence proceedings in respect of a claim more than 3 years after the date of the motor accident to which the claim relates, albeit if the claim is made in respect to the death of a person, the date of the death.
So 109 relates to the commencement of court proceedings. So under these sorts of legislations, you have generally, they're considered to be what's called benefits legislations. So usually legislation will provide a set of like a code of conduct that people must follow. And if they don't follow it, then there are remedies available for a breach. But for things like workers' compensation and MVAs in New South Wales, they are considered to be benefits legislation because most injuries in New South Wales occur on the roads or at work. And so the deleterious effects of these sorts of injuries is that people can't go back to work immediately, and they need medical assistance. And so there are I suppose the term would be positive requirements issued on the insurers for these claims that they have to provide benefits to the claimants. But both workers' compensation jurisdiction in New South Wales and also the motor vehicle accident jurisdiction in New South Wales also entitle what's called common law damages claims, which it follows from, but is more or less separate to the statutory benefits aspect of things. And so this section deals specifically with commencing court proceedings, which is 3 years from the date of the incident, which.
No, well, that's interesting because that's what this case is all about.
Yeah.
All right. So the standard for the leave of the court to be granted for a little claim to be filed late. So the leave of the court must not be granted, it says. So there's a negative provision. Unless the claimant provides a full and satisfactory explanation to the court for the delay.
Yep.
The total damages for all kinds likely to be awarded to the claimant if the claim succeeds are not less than 25% of the maximum amount that may be awarded for non-economic loss.
Yeah. That'll make sense. So the full and satisfactory explanation to the court for the delay in proceedings would be functionally the same in a general public liability claim of explaining to the court why you ought to be entitled to maintain your claim even though you've lodged it out of time. The things that they take into consideration generally are your background, the nature of the injuries, all of the injuries that you've sustained, whether you noticed them immediately, whether you got proper legal advice, and also when you got that proper legal advice, the duration of time that it took for you to act on that proper legal advice. We deal with it. It is something that is dealt with quite somewhat semi-regularly in CTP claims, is that you'll have a claimant who, for example, they have a traumatic brain injury case, or let's just say that they have a motor vehicle accident and they're stuck in a coma for 2.5 months. And then they come out of the coma, they wait 2.5 weeks. So now they're beyond 3 months to make a claim for statutory benefits for their motor vehicle accident claim.
Right.
There's a strict 3-month requirement under the new Motor Accident Injuries Act to make a claim within 3 months. And also to make a claim within 28 days if you want to claim statutory benefits for income replacement. But this dude's been in, for our hypothetical plaintiff, has been in a coma for 2.5 months, and then he waited 2.5 weeks to get legal advice, and then he was told that he should submit a claim form as soon as possible. In those sorts of circumstances, that's the court may take a reasonable view, or not even the court, but potentially the insurer that you would ultimately be lodging it on, or the commission in a motor accident injury claim occurring after 2017, December 2017. They may take a favourable position to it, that your 2.5 months of being stuck in a coma has not necessarily stopped time from running, but has given a good cause for why there was such a delay. Especially considering it can take a while to get a response from lawyers. And but if you, for example, if you're in a coma for 2.5 months, you get legal advice 2 weeks later, so now you're at the 3-month limitation, and then you sit on your hands after you get the advice that you should lodge straight away. You sit on your hands for 6 months. The insurer is going to ask, why were you sitting on your hands?
Oh.
There's arguments to be made.
Election, is it?
Sorry?
Election.
As in
they've elected to allow this claim to lapse.
Yeah. There's arguments that that can be made, and good lawyers will be able to tease that information out of claimants with the provision of appropriate instructions and advice. Ultimately, it comes down to it's a decision of the insurer, and the decision is disputable. And if the decision is disputed, then you go before the commission.
So if I've understood correctly, there's an additional requirement. So if there's an insurance company involved and the insurance company has said, no, we're not going to allow it.
Yeah.
Or they've been responsible, and there's a third party responsible for the delay.
If there's a third party that's responsible for the delay, then that would be that you would have to mention that. Ultimately, because it is very subjective and it's very difficult to provide clear guidelines as to what satisfies a full and satisfactory explanation for the delay. I believe there are some points that will be taken into consideration more favourably than others, such as if there's alternative things like, for example, access to legal advice, and the first time that you got legal advice, how quickly you've acted on that legal advice. and those sorts of things. There's also medical conditions and whatnot that may ultimately, though, it's a subjective test that's sort of a case by case basis.
Yeah. The factors that are to be considered. I mean, I note that it's full and satisfactory, so two parts.
Yeah, and you have to satisfy both of them as well. It is 3 months is not an unsubstantial amount of time, and if you have lodged a claim outside of 3 months, the insurer wants to know exactly why that has occurred, and so you do have to provide every single bit of information that you possibly can to explain, to provide your own background and then provide an explanation. So the full aspect is in relation to you're providing a full explanation of yourself. And then the satisfactory is the subjective test that it is not just an explanation, but it is also a good enough explanation to allow the claim to proceed.
I understand that they were actually admitted to be full in the oral submissions, although it's not in my notes. So the question becomes whether or not it's satisfactory.
That's right.
In the facts of this case, the accident occurred and they consulted with lawyers. They didn't receive formal advice. And there was some discussion about a potential MACA claim, but ultimately it wasn't considered a reasonable avenue until much later in the case. And the injuries sustained at the time of the accident by the injured party were significant. I mean, there's multiple procedures which are described in the judgment, but it's basically receiving brain surgery. So he was probably not in a good position to be able to appropriately consider the advice pertaining to the MACA claim. And then his wife, who was a substantial person in helping to get the claim on foot and in the reception of advice and throughout the process, she gave evidence, and I might refer to how the court describes that actually. Paragraph 20 says, in her affidavit, we're talking about the wife at this point, Mrs. Chapman said that a workers' compensation form was lodged on behalf of her husband by the second defendant on the 4th of August 2016. They commenced the
workers' compensation claim,
after which he began receiving weekly payments. She met Mr. Finney at his office, so that's a solicitor, I understand.
In cross-examination, Mrs. Chapman agreed that different options were discussed at the meeting and that a CTP claim was one of those options.
So Mr. Finney must be her representation.
Seems to be.
So that she has discussed it.
Yeah.
But she also says her recollection wasn't
viable.
Yeah. That's the advice she's received. But it's not formal advice, it's verbal advice. And she did not recall any discussion about time limits. She said that the first meeting was purely advisory and that she was not then in a fit state to seriously consider any advice, which I accept.
Right.
The courts accepted it. And, in the context of them enumerating the procedures that Mr. Chapman has had, I can sort of understand that. It seems like it was a life or death thing, very much in the balance. And, considering his brain injury incurred, it's not clear what harm may have been suffered until after the surgeries are complete. So, it's just, it's been raised, but she hasn't understood it. She hasn't considered it, and it hasn't continued.
And out of curiosity, are you aware whether Mr. Chapman had a tutor appointed? If you've got a brain injury,
I don't believe that a tutor was appointed in this case.
Right.
Mrs. Chapman handled a substantial amount of the proceedings. Mr. Chapman came back later, but there's some discussion. Actually, I might go to that part of the discussion. Okay, the plaintiff's affidavits were read. So that's Mr. Chapman. They annexed a great deal of medical and financial material. He could only vaguely recall signing those documents. In the cross-examination, the plaintiff said he had no recollection about what had occurred in the meeting of August 2018. And he could not honestly say if a motor accident claim was mentioned and that he relied on his wife to explain what had happened after the meetings with the lawyers. The court considered as particularly that, quote, there was no suggestion that his lack of memory was inconsistent with the brain injury that he suffered in 2016. It's quite understandable. A traumatic brain injury might complicate remembering a complex legal analysis. All right, so they've had it raised, but it's generally not been considered seriously. It hasn't been raised in evidence. It hasn't been provided particular advice. They haven't received particular advice as to a MACA claim.
And so what I think this is kind of circling around just at the outset before we get further into it, it looks like the court is trying to make an evaluation as to whether the motor accident claim was voluntarily dismissed by the claimant, or whether it just wasn't seriously considered by them at the time. Because if you've seriously considered it and then said, I don't want those benefits, I choose not to make a claim, it's very different to I don't know what the benefits are and I haven't made a choice.
Well, that's very interesting because the defendant's submissions speak about that. Okay. Paragraph 35. Mr. Katsanos submitted that the plaintiff, through his wife, had made a conscious election not to pursue a MACA claim. The nub of his argument was that the plaintiff, through his wife, had consciously made a deliberate and informed decision in the period August 2016 to August 2018 to pursue his rights pursuant to the Workplace Injury Management Act 1998 as against the first defendant, and the Civil Liability Act 2002 as against the second defendant. It could not now elect to also pursue his rights pursuant to MACA as against the third defendant. In fact, those decisions came later, in April 2020 as against the first defendant and October 2020 as against the second defendant. In particular, Mr. Katsanos replied upon the comments of Hanley acting justice appeal. His Honour then was in Walters and Cross Country Fuels Proprietary Limited 2009, New South Wales Court of Appeal 10 Walters at paras 37 to 40, where His Honour discussed the issue of election in the context of principles set out as follows. I agree with both previous judgments. I could only add for myself some brief supplementary remarks in ITEC, which I understand is the outstanding authority presently for election. In Graphics Proprietary Limited and Elliott, a 2002 case of number 54, New South Wales Law Reports 207, His Honour, giving the principal judgment of this court, said a deliberate decision to allow a statutory limitation period to expire would be a powerful factor against the grant of leave. Where a deliberate decision to allow the period to expire has been made, ordinarily it will be difficult to provide an explanation for that decision sufficiently cogent to warrant grant of leave. There is ample authority to this effect. So if as you said, injured parties have understood their rights and chosen not to take up a claim, if they're aware of a claim, they've chosen not to pursue a claim, then they have elected to allow the claim to expire and accordingly should be availed of any delay.
And that operating word is deliberate, that they knew what they were doing, and that they have specifically chosen a course of action, understanding the ramifications of that.
Exactly, yeah. All right. So we might jump to section 66.2, which then gives us the threshold. Section 2 defines the phrase full and satisfactory. So it's actually a statutory defined term, as well as some additional judicial explanations. Section 66.2, in this chapter, a reference to a full and satisfactory explanation by a claimant for non-compliance with a duty or for delay is a reference to a full account of the conduct, including the actions, knowledge, and belief of the claimant from the date of the accident until the date providing the explanation. The explanation is not a satisfactory explanation unless a reasonable person in the position of the claimant would have failed to have complied with the duty, or would have been justified in experiencing the same delay.
Yeah. So it's the reasonable person test, which is an objective test, but it's very similar to 5 capital, I believe it's 5 capital O or 5 capital P in the Civil Liability Act, where you are making a claim against a professional, and the duty of care changes from the reasonable person to a reasonable person in a body of peers against a professional acting in a professional capacity. And there is somewhat of a I guess a correlatory effect or a cross relation to that, in that you have to take the claimant and you have to judge a reasonable person in the position of the claimant, as opposed to just the reasonable person.
So in this case, you're looking at someone who's undergone multiple brain surgeries, had a traumatic brain injury, who's in hospital in an extended period for
that's
how long. They don't know whether that person is, to what degree they're going to be affected by this brain injury.
That's right.
Their home is thrown into chaos. Their children and their wife are present beside them, and big things are going on.
Yeah. And then you also take into consideration their background, and because all of these things, they all feed into summating a reasonable person in the position of the claimant, and then whether that reasonable person in the position of the claimant would have probably, so it's on the balance of probabilities, would probably have what's the wording? Experienced that same delay.
So, sticking to this case, the person is not a personal injury lawyer who's aware of the relevant periods.
That's right.
So,
going back to election.
Going back to election.
Yeah.
The court says at paragraph 29, as to the question of election, to which see below, and we've already, I think, quoted the below paragraph, but Mr. Demerick submitted that iTech Graphics Proprietary Limited and Elliott, which is one of the preeminent authorities in that on election, had no application, as in that case, the claimant had made a conscious and deliberate decision based on legal advice to let the limitation period expire. Further, he had submitted that in this case, the only decisions which were made by the plaintiff's wife as the controlling mind, so it's close to each other, but not. And the cases show that the focus must be on the claimant himself as the reasonable person. Himself. He submitted that it was clear that Mr. Chapman cannot recall ever being told about bringing a motor accident claim, and so he cannot have said to have ever made a conscious decision about foregoing. It's sort of interesting that the evidence so far on either examination, both be it the wife as the controlling mind or the husband not recalling anything, the judge seems to have accepted to some degree that it was never brought up. It was never explained to either of them.
Yeah.
And neither of them considered it properly in the context of receiving legal advice and considering and understanding that legal advice.
Yeah. Well, at its highest, it seems like Her Honor accepts that the legal advice that was proffered to the claimant was at best informal verbal legal advice. And also I recall a section of the case report that dealt with accepting that Mr. Chapman's memory loss issues did seem to logically flow from his brain injury. And so there is a bit of a synthesis there between his impairment arising from the motor accident, or I should say the work-related motor accident, and his I want to withdraw from using the word choice, but his inaction in lodging a claim in time.
So the second defendant goes further than that. It says, paragraph 35, Mr. Castanos submitted that the plaintiff through his wife had made a conscious election not to pursue a MACA claim. And the nub of his argument was that the plaintiff through his wife consciously made a deliberate and informed decision in the period of August 2016 to August 2018 to pursue his rights pursuant to the Workplace Injury Management Act 1998.
And the Civil Liability Act 2002, and could not now elect to also pursue against the third defendant, I believe the third defendant or the second defendant.
This is the second defendant, so I think it's fair to pursue
the MACA claim is against the third defendant. So the workers' compensation claim is against the first defendant, and the Civil Liability Act is against the second defendant, and the hypothetical MACA claim or the proposed MACA claim is against the third defendant.
So because he's made those two early claims, he's abandoned his rights.
Not necessarily, or at least I don't interpret it that way. It's I don't think that Mr. Katsanos is suggesting that making the first two claims under the workers' compensation legislation and under the Civil Liability Act is tacit approval that he is making that he is abandoning his claim in under the Motor Accident Compensation Act. I think what Mr. Katsanos is trying to put forward to the court is that there was a deliberate choice to not make a claim under the Motor Accident Compensation Act. And the evidence for that conscious choice comes from the fact that he did make a conscious choice to make a claim under the Civil Liability Act against the second defendant and under the workers' compensation legislation against the first defendant. And so it's a bit of I think it's a correlatory argument that he's making, that Mr. Chapman, the plaintiff, knew of his rights and entitlements with respect to his personal injury in workers' compensation and in civil liability. But then he was, for some reason, ignorant of his entitlements to make a motor vehicle accident claim in circumstances where he had a motor vehicle accident. Does that follow? Does that make sense?
Yeah, I'm I'm considering what you're saying.
Because the thrust of it from Mr. Katsanos, as summarized by the court, is that he made a conscious decision to not pursue his rights under the Motor Accident Compensation Act. And I'm sure that Mr. Katsanos probably made some very well reasoned submissions that go into great detail. But I don't believe that it was just because he chose to. I don't think that it's a matter of election that he's chosen. He's chosen for workers' comp and for civil liability, and he has chosen. And because he chose those two, he ignored the motor vehicle accident. I think he's using that just as correlation, that he had the capacity to choose, and so the fact that he did, means that the fact that he knew that he could choose those means that at some point in time he ought to have turned his mind to the existence of a motor accident claim. And he has likely done that, or a reasonable person in his position would have done that, and then made a decision. And the fact that he has not made that decision means that it is a deliberate election to not make that claim.
Well, that inference as to the full submissions, which I mean we don't have the full submissions available to view. We have the judgment, would make sense in context with the expressed preliminary view that there wasn't available a feasible MACA claim.
It is very interesting, and I can certainly see a line of argument following from Mr. Katsanos, following from the court summation of Mr. Katsanos' submissions, that if you knew that you had a workers' compensation claim and you knew also that you had a civil liability claim under the Civil Liability Act, which is not a normal occurrence, then why did you know about those but you didn't know about the motor accident claim? Unfortunately, the way that I've just framed it then makes it seem like it's a bit of conjecture, and I don't think that it's fair to make that sort of a conjecture.
Yeah, we're hypothesizing about things we don't know.
Yeah,
but sometimes it's fun.
It is, yeah.
We're not, there's no impact. We're not in the decision of this judgment. We're not having any impact on the judgment this time comes, and everyone watching should be aware that
definitely, yeah. And we're not jumping into the case either.
We're saying we don't have the full submissions, but we're hypothesizing about what they might have been. And it kind of makes sense, actually, in some of the contexts of the other arguments being made. I'd be curious to talk to the representation to see what they actually argue. All right. Let's see. So the judge ultimately allowed the application. They said they allowed the claim to be amended. Paragraph 43, quote directly from the judgment. In my opinion, taking into account the evidence before me, neither the plaintiff nor his wife were ever provided full advice about making a claim pursuant to MACA. Mrs. Chapman was only aware in August of 2018 about the time limit for forwarding a claim form. Perhaps that should also be read, perhaps that Mrs. Chapman was the only one who was aware. Mrs. Chapman was then told that a green slip claim was not viable. Indeed, until January 2022, when the Chapmans were informed about the second defendant's belated view that MACA might apply, neither the claimant nor his wife had any advice, idea, or information about the possible application of the MACA to the proceedings. I observed that up to November 2021, notwithstanding the involvement of many experienced solicitors and barristers over several years, no lawyer had ever considered, and I find this very interesting, no lawyer had ever considered that the MACA might apply to the instant proceedings. This fact and the circumstances of this case, in my view, is crucial to the assessment as to whether a reasonable person in the plaintiff's position would have been justified in experiencing the delay. The plaintiff is essentially compelled to now join the third defendant, which he did expeditiously and without prejudice being occasion to it. It follows that, in my view, by reference to an objective standard and given Mr. Chapman's position, the delay that has occurred is reasonably justifiable. And then there's a reference given, Justice Gleeson. I am therefore satisfied the plaintiff has provided a satisfactory explanation within the meaning of Section 66(2) of the MACA. So they said it is just and reasonable for leave to be granted to commence the proceedings. So they expanded the claim to be made.
It can be a bit fraught for solicitors providing advice on what is and isn't blameless. What the legislation is usually interpreted as intending to capture through having a no fault provision. It is very common that when a motor vehicle accident occurs, somebody gets a fine from the police for causing the accident, for failing to stop at a red light, as an example, or failing to give way as required, or for negligent driving, or so on and so forth. But in circumstances where that's not available, and in circumstances where there are substantial vitiating factors, like, for example, there may be an animal that comes out of nowhere, and you don't have, and a prospective claimant doesn't have time to stop, that may be grounds to consider a blameless motor vehicle accident. But then the actual provision of a blameless accident in the Motor Accident Injuries Act, it's the Motor Accident Injuries Act, not the Compensation Act, although Mr. Chapman would have proceeded under the Sorry.
It's just an older case, sorry.
It's just an older case. He proceeded under the Compensation Act. And that's just because it was an accident that occurred in 2016, and the Motor Accident Injuries Act didn't assent until December 2017. So Section 5.1 of the Act defines a no-fault motor accident to mean a motor accident in the state, so in the state of New South Wales, that is not caused by the fault of the owner or driver of any motor vehicle involved in the accident, in the use or operation of the vehicle, and not caused by the fault of any other person. So when you think of that definition, common examples that may come to mind in identifying a no-fault accident may be where an animal runs across the road and the driver doesn't have time to stop the vehicle and collides with the animal and sustains a personal injury as a result. The next section, Section 5.2, it assigns liability to an individual, and it says, quote, subsection 1, the death of or injury to a person that results from a no-fault motor accident involving a motor vehicle that has motor accident insurance cover for the accident within the meaning of Section 1.10 is for the purposes of and in connection with any claim for damages in respect of the death or injury deemed to have been caused by the fault of the owner or driver of the vehicle in the use or operation of the vehicle. So it's a very interesting case, actually. It deals with a very it's not something that you have to handle every day. Only a very small proportion of claimants have this sort of, and it seems like one of those things where everything kind of blew up. Because not many claimants are going to have to go all the way to the district court or the Supreme Court to argue a case about whether they have provided a satisfactory explanation for the delay in commencing proceedings. And also, not many people are going to be in circumstances where they have been provided with advice that they don't have a motor accident claim when in fact they do. Or in circumstances where they may have a motor accident claim. And then, of course, Mr. Chapman had very interesting vitiating circumstances in that he had a significant brain injury, and it seems as though the claim, the allegation that there was a claim, or the suggestion that there was a claim under the Motor Accident Compensation Act arose, it seems to be when one of the defendants likely pleaded that Mr. Chapman was not entitled to recovery of full damages because he had not joined one party to the proceedings.
Precisely.
Yeah.
Is excluded, yeah.
Yeah.
All right. It's a really interesting case.
It is.
Start to finish this newest stuff.
That was a really good one, actually. Yeah. Yeah.
All right. Thanks for joining us, everyone. And this has been the Caselaw Club.